We've talked about reps and warranties and indemnification. What happens if you breach any of them? Now we're going to talk about escrow, which is the part of the consideration that's usually used to address any breaches in the reps and warranties.
Let's start with the concept of escrow. What is escrow?
So an escrow, which is also referred sometimes to as a holdback, is the amount of the consideration that's held back or put in escrow for a period of time to satisfy any breaches of reps and warranties. Now, a typical amount of escrow for a deal is somewhere between 10 and 20%, and the escrow is typically held in escrow for somewhere between a year and 2 years. So that's the range. Sometimes you'll see things outside that range, but that's the normal range. So if you sell the company for $100 million in cash, you're really only getting 80 million of it up front if there's a 20% escrow. And 20 million of it is going to sit in the escrow account, earning some interest, but usually not very much, until the point at which the escrow time frame is satisfied. Let's say in this case, you go for a higher escrow amount, 20%, but a shorter time frame, a year. So after a year, if there are no claims against the escrow, you get your $20 million paid out as well.
What would be some typical claims that might be made against escrow?
One example thing that ends up in the escrow account oftentimes would be any sort of legal disclosure. So disclosure that you have rights to all of your intellectual property, rights, a knowledge rep that you don't have any legal issues outside what's disclosed in the disclosure statement. Another one would be licensing of software, that you've licensed all of your software correctly. If after the deal closes, something comes up to the buyer that you haven't done these things, again, anything that could be in the reps and warranties, their first recourse is to go against the escrow. Interestingly, in a lot of cases, as the seller, you may still be involved in the company and the buyer, so you can help mitigate some of these things. Let's say it's a licensing agreement that's actually just not quite right, but you have the history of why it's not quite right, and you can work with the buyer to work through it. But in other cases, if the founders or the people in the company aren't part of the acquirer, it's often more contentious because there's nobody still in the buyer that really cares about anything around that particular issue other than satisfying the payment of it.
And how common are claims against escrow?
It varies a lot. I would say that deals tend to fall into one of two categories. They're either totally clean and there's no issues, or they're a mess. It's hard to predict actually on the front end which they're going to be, because a lot of times the ones that are a mess, the issues that come up after the deal closes are a surprise. Most sellers will represent that there's no issues and that the buyer shouldn't worry about it. And most buyers try hard to define what those issues could be, put them in the reps and warranties, and use the escrow to satisfy it. I'd say in our experience as investors, we get paid out 100% or very close to 100% on the vast majority of escrows that we're involved in. And every now and then there's something that comes up that is a meaningful impact on the amount that we get paid out. There are plenty of stories, though, of acquisitions where the seller had a lot of issues post-close, there was a lot of contention, and the amount of the escrow that actually got paid out was very small.
So in the case where you had a company bought for 85 million, was that escrow held by a third party, or you said that the company actually ended up tanking, and so you don't have to worry about that escrow going away if the company doesn't succeed, right?
The escrow is almost always held by a third party, but not always. There is this construct of a holdback where the seller creates a holdback of the amount. In the situation I described earlier, we had, I believe, about a 10% escrow. And I remember after the escrow, after a year, the buyer, who was now struggling financially, made a claim against half the escrow, about $4 million of the escrow. And the claim was completely arbitrary and specious. And they made the claim because they just figured, well, here's a chance to get some of the money back from the escrow. We fought. It took us about 6 months, and we got 100% of that money because their claim wasn't valid. So there's a process that you go through, which can either involve mediation or litigation. In our case, we had a mediation clause, and they threatened litigation. And ultimately, I think the CEO of the company, again, public company, realized that what they were asserting was invalid and they paid out the escrow. But it can be very difficult, especially a year or two later, when things haven't necessarily gone as planned. It's not quite that same comfortable conversation when, the day before the acquisition closes, when even though you've been negotiating hard, everybody's super excited about getting things done.